Welcome back to our channel Finance Kita. If you're diving into the world of insolvency and bankruptcy, especially as an aspiring insolvency bankruptcy professional IBP, you've clicked on the right video. Today we're going to tackle some key interview questions that you might encounter in your journey to becoming a CA or a finance expert in this niche. Before we jump in, don't forget to check out our other technical interview videos linked in the description below. You can speed up the playback if you want to absorb this information faster, and I recommend watching these videos 2 to 3 times before your interview. Trust me, it'll help you feel more prepared. And please share this with your friends who are also gearing up for their finance interviews. All right, let's get started. First up, what is the Insolvency and Bankruptcy Code, IBC, and when was it enacted? To answer this, you can say the Insolvency and Bankruptcy Code, or IBC, is a comprehensive law enacted in India in 2016 to consolidate and amend the laws relating to the reorganization and insolvency resolution of corporate persons, partnerships, and individuals. The primary aim of the IBC is to promote entrepreneurship and balance the interests of all stakeholders involved in the insolvency process. Moving on to our next question. Can you explain the key objectives of the IBC? Here's how you could respond. The key objectives of the IBC include promoting the resolution of insolvency in a time-bound manner, ensuring maximization of asset value, balancing the interests of all stakeholders, and providing a clear framework for the insolvency process. Essentially, it aims to create a more robust environment for doing business and to help distressed companies recover more efficiently. Now let's talk about how the IBC improves the insolvency resolution process compared to previous regulations. You can say the IBC has introduced a streamlined and time-bound process for insolvency resolution, which was lacking in previous regulations. Earlier laws, like the Sikh Industrial Companies Act, often led to prolonged litigation and delays. The IBC, on the other hand, mandates that the resolution process should be completed within 180 days, extendable by another 90 days, ensuring that companies can either be revived or liquidated quickly, which helps preserve value. Next, we have what are the different types of insolvency proceedings under the IBC? You could respond, the IBC outlines several types of insolvency proceedings, including the Corporate Insolvency Resolution Process, CIRP, individual insolvency proceedings, and the liquidation process. Each of these proceedings serves a specific purpose, whether it's to revive a distressed corporate entity or to liquidate its assets in an orderly manner. Now, let's dive into the process of initiating the Corporate Insolvency Resolution Process, CIRP. You might say, the CIRP can be initiated by either the corporate debtor or a financial creditor. The process begins with the filing of an application with the National Company Law Tribunal, NCLT. Once the application is admitted, an Interim Resolution Professional, IRP, is appointed to manage the affairs of the company, and the resolution process kicks off. It's crucial to ensure that all necessary documents are submitted to avoid delays. Next question, what are the roles and responsibilities of an insolvency professional IP during CIRP? To answer this, you could say an insolvency professional plays a pivotal role during the CIRP. Their responsibilities include managing the operations of the distressed company, conducting meetings of the Committee of Creditors, COC, evaluating resolution plans, and ensuring compliance with the IBC. They act as a bridge between the stakeholders and ensure that the process runs smoothly and transparently. Now, let's get a bit personal with this question. Describe a case where you were involved in the resolution process. What were the key challenges and how did you address them? You might respond, in one particular case, I was involved in the resolution of a mid-sized manufacturing company facing severe cash flow issues. One of the key challenges was the lack of cooperation among creditors, which was causing delays. To address this, I organized a series of meetings to facilitate open communication, ensuring that all voices were heard. This helped in building trust and eventually led to a consensus on the resolution plan. Next, we have how do you handle creditor claims and manage meetings of the Committee of Creditors, COC? You could say handling creditor claims requires meticulous attention to detail. I ensure that all claims are verified and documented accurately. During COC meetings, I focus on creating an inclusive environment where creditors can express their concerns and suggestions. This helps in fostering collaboration and ultimately leads to better decision making. Now let's discuss. What strategies do you use to maximize the value of assets during the resolution process? You might respond, to maximize asset value, I adopt a multifaceted approach. This includes conducting thorough valuations, identifying potential buyers early, and exploring various restructuring options. Additionally, I ensure that the assets are well maintained during the resolution process to prevent any further depreciation in value. Next up, what are the key amendments to the IBC and their implications on insolvency proceedings? You could say, since its enactment, the IBC has undergone several amendments aimed at refining the process. For instance, recent amendments have introduced provisions for fast-tracking the resolution process for micro, small, and medium enterprises, MSMEs. These changes have made it easier for smaller businesses to navigate insolvency, thereby promoting entrepreneurship and economic growth. Now let's tackle, how do you ensure compliance with the IBC and related regulations? To answer this, you might say, ensuring compliance involves staying updated with the latest regulations and guidelines issued by the Insolvency and Bankruptcy Board of India, IBI. I also maintain a robust internal checklist to track compliance at every stage of the process. Regular training sessions for the team help in reinforcing the importance of adhering to the IBC. Next question. Can you explain the role of the National Company Law Tribunal, NCLT, and the Insolvency and Bankruptcy Board of India, IBBI, in the insolvency process? You could respond, the NCLT is the adjudicating authority for insolvency cases, responsible for admitting applications and overseeing the resolution process. On the other hand, the IBBI is the regulatory body that formulates regulations and guidelines for the insolvency profession. Both play crucial roles in ensuring that the process is fair and efficient. Now let's move on to, how do you conduct a financial analysis of a distressed company? You might say, conducting a financial analysis involves reviewing the company's financial statements, cash flow patterns, and operational efficiency. I also assess the company's liabilities and obligations to understand its financial health better. This analysis helps in identifying the root causes of distress and informs the resolution strategy. Next up, what valuation methods do you use to determine the worth of assets and liabilities? To answer this, you could say, I typically use several valuation methods, including the income approach, market approach, and cost approach. Each method provides different insights, and I often triangulate these valuations to arrive at a fair estimate of the company's worth. This helps in making informed decisions during the resolution process. Let's get a bit technical with the next question. How do you handle complex financial structures and transactions in insolvency cases? You might respond, handling complex financial structures requires a deep understanding of the company's financial history and the various stakeholders involved. I often collaborate with financial analysts and legal experts to dissect these structures, ensuring that all aspects are considered during the resolution process. This collaborative approach helps in identifying potential risks and opportunities. Now let's discuss, what steps are involved in preparing a resolution plan and how do you evaluate its feasibility? You could say preparing a resolution plan involves several steps, including assessing the financial position of the company, identifying viable options for restructuring, and engaging with stakeholders. To evaluate feasibility, I conduct a thorough analysis of the proposed plan against the company's cash flow projections and market conditions. It's essential to ensure that the plan is realistic and achievable. Next question, can you explain the process of liquidation under the IBC? What are the key considerations during liquidation? To answer this, you might say, the liquidation process under the IBC begins when the NCLT orders the liquidation of a company. An appointed liquidator takes charge of selling the company's assets and distributing the proceeds among creditors. Key considerations during liquidation include ensuring compliance with legal requirements, maintaining transparency, and maximizing asset value to benefit stakeholders. Now let's tackle, how do you deal with issues related to fraudulent transactions and assets in insolvency proceedings? You could respond, addressing fraudulent transactions requires a keen eye for detail and thorough investigation. I collaborate with forensic experts to identify any irregularities and take appropriate action to recover assets. It's crucial to ensure that all transactions are scrutinized to maintain the integrity of the insolvency process. Next, we have how do you maintain impartiality and objectivity as an insolvency professional? You might say, maintaining impartiality is critical in my role. I ensure that I approach each case with an unbiased mindset, treating all stakeholders fairly. Regular self-reflection and adherence to ethical guidelines help me stay grounded and focused on the best interests of all parties involved. Now, let's discuss a more personal topic. Describe a situation where you faced an ethical dilemma in an insolvency case. How did you handle it? You could respond, in one instance, I was faced with pressure from a creditor to favor their interests over others. I took a step back and reminded myself of my responsibility to uphold the principles of fairness and transparency. I facilitated a meeting with all stakeholders to discuss the concerns openly, ensuring that everyone had a voice in the resolution process. This approach helped in maintaining trust and integrity. Next question. What measures do you take to ensure transparency and fairness in the insolvency process? To answer this, you might say, ensuring transparency involves clear communication and documentation at every stage of the process. I provide regular updates to stakeholders and conduct open meetings to discuss progress and challenges. This transparency helps in building trust and ensures that all parties feel included in the process. Now let's tackle how do you manage stakeholder expectations and conflicts during the resolution process? You could respond, managing stakeholder expectations requires clear communication and setting realistic timelines. I focus on understanding the concerns of each stakeholder and work towards finding common ground. Regular meetings and updates help in addressing conflicts early on, preventing them from escalating. Next up, what strategies do you employ to handle stress and pressure in high-stakes insolvency cases? To answer this, you might say, handling stress in high-stakes situations requires a combination of time management and self-care. I prioritize tasks, break them down into manageable steps, and ensure that I take breaks to recharge. Additionally, I lean on my support network of colleagues and mentors for guidance and encouragement. Finally, let's discuss. Can you discuss a particularly challenging insolvency case you worked on and how you navigated through the difficulties? You might respond, one of the most challenging cases I worked on involved a large conglomerate with multiple subsidiaries. The complexity of the financial structures and the diverse interests of stakeholders made it particularly difficult. I navigated this by breaking down the process into smaller, manageable parts and ensuring that I had a clear communication strategy in place. By fostering collaboration and transparency, we were able to reach a resolution that satisfied most parties involved. More finance knowledge. Good luck with your interviews, and I'll see you in the next video.